You've picked a name you absolutely love, and you're right on the brink of filing that trademark application.
The packaging mockups are ordered, the perfect domain is reserved, and your pitch deck is built and ready to go. This explainer covers exactly what a trademark examiner actually checks before approving a mark and what applicants routinely miss right before they file. Now, the procedural reality of the United States Patent and Trademark Office is that the examining attorney's search only happens after the applicant has already paid a non-refundable filing fee. Based on the January 2025 fee schedule, that base application filing fee is $350 per class of goods or services. A multi-class application can easily run $700 to over $1,000, and every bit of it must be paid before any examination even begins. By the time that fee is processed, the search is no longer being done for your benefit. Drawing on our examiner side experience, we know that the USPTO's search exists purely to find grounds to refuse the application. A proper clearance search conducted before filing is a completely different exercise. It's done specifically to protect the applicant's investment, their brand, and their timeline before any money changes hands. Question 1. Do we actually need a clearance search before filing, or can we just rely on the USPTO's own review? The short answer: the USPTO strongly recommends doing a clearance search before you file. Relying solely on the examining attorney to find conflicts effectively transfers all of your brand risk onto the application itself. You're basically paying the government to tell you if you have a problem rather than identifying that problem before you pay. Step 1. The Federal Trademark Database. Step 2. State trademark registrations. And Step 3. Common law rights. To understand why skipping this is so risky, we have to look at what a proper clearance search actually covers. It's definitely not just a single database lookup. A comprehensive clearance search is built on these 3 distinct layers. Question 2. What does the examining attorney check? And what does that leave uncovered? The examining attorney only ever checks that first layer, the federal database. They don't search state databases, and they definitely don't search for common law use. Because of this, state and common law conflicts can easily surface later, even after federal approval, completely disrupting a business that thought it was safely in the clear. Common law trademark rights are easily the most frequently overlooked category. Here's a fact that surprises a lot of applicants. In the United States, trademark rights arise from actual use in commerce, not simply from registration. So, a business operating for years without a federal application still holds enforceable rights in its geographic area. These marks won't show up in federal searches, but they will surface in business directories, domain registrations, social media platforms, and state filings. Section 2D, Likelihood of Confusion. When the examining attorney does search the federal database, they're primarily looking for 2 things. The most common refusal ground issued by examiners is Section 2D. This happens when a proposed mark is judged just too similar to an existing one, making it likely that an ordinary consumer would be confused about the source of the goods or services. To figure out this likelihood of confusion, examiners apply a multi-factor test known as the DuPont factors. They weigh the similarity of the marks in appearance, sound, meaning, and overall commercial impression right alongside the relatedness of the goods and services. A refusal can issue even when marks share only 1 or 2 dominant words. Because this analysis gets highly detailed, our source article breaks down all 3 layers of a clearance search step by step, including exactly where those common law rights typically turn up. That full breakdown, along with a detailed look at the DuPont-style analysis, is linked in the first comment below. Section 2E1, Merely Descriptive Marks. The second most common refusal ground applies to merely descriptive marks. If a mark immediately describes a quality, an ingredient, a characteristic, or a function of the goods or services, it's going to be refused on the principal register. Think of naming a coffee product cold brew coffee, or a logistics service fast delivery. Both likelihood of confusion and merely descriptive refusals can be completely anticipated with a proper search before filing. Question 6. What actually counts as confusingly similar in an examiner's eyes? The standard evaluates so much more than just identical spelling. Identical spelling versus overall commercial impression. Examiners look at the total effect of the mark. Commercial impression is really the broadest dimension of this test. This means 2 marks can look completely different on paper, but if they create the exact same overall mental association for consumers, they can still be refused. Examiners evaluate that total effect, not just the individual components in isolation. Confusing similarity extends well beyond exact matches into phonetic equivalents and translations. Excel, spelled with an X and a C, is routinely found confusingly similar to Excel, spelled with an E. The test is how a consumer would say the mark out loud, not just how it's written. And it goes even further. Under the doctrine of foreign equivalence, a mark in a foreign language may be translated and compared to an English language mark. So a mark that means golden in Spanish can easily conflict with an existing golden mark in English, assuming the goods are related. Question 3. Can we run this search ourselves, or does it require professional help? Knowing how broad the examiner's net actually is, running an exact match search in the USPTO database yourself often generates a lot of false confidence. A self-search typically completely misses state registrations, common law use, phonetic equivalents, and foreign language translations. Misreading those initial results provides a very dangerous sense of security. Question 4. What does a proper clearance search cost, and how long does it actually take? A professional clearance search covering all 3 layers, federal, state, and common law, typically runs between $500 and $1,500, depending on the scope and complexity of the mark. The process generally takes 2 to 5 business days to generate a comprehensive report and a defensible assessment of registrability. Question 5. What happens if we skip it and someone already has rights to the name? Well, if a prior mark is found by the examining attorney, the applicant faces some really difficult and expensive options. You can attempt to argue against the refusal, try to seek consent agreements from the prior registrant, or attempt to amend your identification of goods. All of these require significant time and legal fees, with absolutely zero guaranteed success.
The consequences of skipping clearance follow a very clear escalating sequence. Phase 1, that $350 per class filing fee is gone regardless of the outcome. Phase 2, when the examiner issues a substantive office action refusal, a proper legal response typically runs $1,500 to $3,500 in attorney fees. Phase 3, if those arguments fail and the name is already in the market, the business faces a forced rebranding. Rebranding a company, buying new domains, reprinting packaging, and losing market recognition costs far more than the prior legal fees combined.
The clearance search is the absolute cheapest point in the entire process to catch a conflict. The filing fee is the second cheapest. Every single step after filing gets progressively more expensive. Finding a conflict before filing allows you to pivot before your capital is locked into an unregistrable brand.
The full article covers exactly what a proper search should include, how to interpret the results, and what it typically costs. You can find it linked right in the first comment. And be sure to subscribe to the channel for more USPTO and trademark guidance without having to search for it every time you face a new filing decision. Is your brand investment currently resting on a one-layer search?